Hi there, I'm Hallie Zobel, and I'm here to talk to you this morning about a probate without going to court. I'm a probate attorney here in Florida. Probate is usually the proceeding where you go to court when someone passes away and someone's appointed to settle their estate. That means pay their creditors and distribute assets to the heirs. But there is a way to do it without going to court. I had a gentleman call into my office about a month ago. I knew him through church, and he explained his wife had passed away recently, and all she left was a small checking account with about $1,400 in it. He didn't really want to go to court, and he asked, did he need a lawyer and did he have to go to court? Apparently, the checking account didn't name any beneficiary. Well, good news for him, there is a way to do that. Florida has something called a disposition without administration. That means someone, an individual, without an attorney, can go to the clerk's office in the county where the person has passed away and fill out some documents, and the court may go ahead and order the asset to be distributed to the heir. Now, of course, there's certain rules around that, and let's go through that so you have a clearer understanding. So, it must be a small estate. Generally, it's under $6,000, and there has to be no real property. What's real property? That includes your house, your beach condominium, your vacant lot. So, if there's a person who has paid final expenses, maybe they've paid the funeral bill and they're an heir and they want to get reimbursed, they can petition the court if there's no real estate, like I said, and any expenses are less than the value of the assets, and the personal property is exempt from creditors. Some personal property is exempt from creditors, and I don't mean to get too technical, but the law allows certain things to pass through to beneficiaries without creditors claiming it. And so navigating this can be real tricky. You can obtain the documents from the clerk's office where the decedent resided, like I said, and then the clerk can advise you if the case is eligible for this. And if so, the court's going to authorize transfer of that checking account, the property, to you. So, things that the clerk's office is going to need. You'll need a death certificate of the person who passed. You're going to need a copy of a funeral bill that's been paid. An original will, if there is a will. You'll need signed consents from the heirs. And you'll need a creditor statement that there's no creditors to the estate and a copy of any medical bills. This is much simpler, and that's why this law was created for this exact situation, but there can be risks going forward. You should always contact a qualified attorney to make sure that this is the best option for you and your family. Thank you for listening this morning, and remember, I can always be reached at hzobel@pcc.law or private corporate counsel telephone number 407-647-7887.